These underlined terms are the explicitly stated elements of the question, but we think that most of the sub-elements or issues are under the problems and limitations category. We're aiming to analyze the problems and limitations with the new Small Business Restructuring Process, or SBRP for short, with a particular focus on how SBRP simplifies the means to restructure small businesses, maximize survival. We need a more flexible and streamlined insolvency procedure to assist small businesses. Lower costs, higher creditor returns, and company rehabilitation is the goal. The new SBRP, or debtor in possession regime, is one step in this direction towards short time limits, reduced formalities, online innovations, and generally simplified procedures which reduce costs of insolvency. Remember, the MSMEs have needs that are different to large companies, so a separate kind of voluntary administration was needed for some time. It had to reduce costs of external administration by only monitoring directors while they lead a restructuring. But directors must also be reassured that they can act without fear for their various liabilities, for example, insolvent trade. The Small Business Restructuring Process was introduced into the Corporations Act 2001 from 1st of January 2021 through the Corporate Insolvency Reforms Act 2020. It is found in Part 5.3b of the Corporations Act, and it provides a modified mechanism of restructuring for very small insolvent businesses who attempt to survive. To even start talking about the Small Business Restructuring Process, we have to first understand previous formal restructuring procedure. I'll first provide a bit of background on insolvency law and highlight the difficulties faced by MSMEs, short for micro, small, and medium enterprises, until the SBRP, Small Business Restructuring Process, was introduced from the first day of this year. Corporate insolvency law's purpose, which is one of several from the Harmer report, is to achieve a fair, efficient, and orderly process in dealing with financial affairs of insolvent companies. Clearly, without these laws, there would be chaos, and only powerful creditors might win. Chapter 5 of the Corporations Act concerns all four types of external administration. For example, under the voluntary administration provisions of the Corporations Act, an external administrator is brought in by the company or its creditors or the court, who is both registered and independent, takes complete control of the company. This helps to increase the likelihood that a company continues to operate by rehabilitating it, or otherwise provides a better return to creditors in an immediate liquidation. Deed of company arrangement could be used to achieve this. New SBRP is like an alternative to voluntary administration. Similarly, less desirable liquidation or winding up process simply involves the liquidator in control and creating liquid assets to distribute before deregistration. It now also has a new simplified liquidation counterpart, or alternative process, with certain eligibility criteria just like SBR. Creditors' participation and other reporting requirements are reduced to achieve simplification. Also a characteristic shared by SBRP. These simplified liquidation provisions are Section 498 and all of Subdivision B, namely sections 500A to 500AE, which is beyond the scope of our topic, although its similarity to SBRP can be noted. Now that we know about the old restructuring procedures and that SBRP is an alternative to voluntary administration, VA, while simplified liquidation, SL, is the alternative for liquidation, we might wonder what MSMEs were doing before all this. Well, they were most likely not engaging with these processes. It's just too costly and unfeasible. See ASIC's insolvency stats, particularly the highlighted cells. I counted 14 forms of external administration to choose from. But in South Australia, for example, restructuring and restructuring plan had zero uptake. Only one company in South Australia used the new simplified liquidation process in the second quarter of this year. I see no evidence of a tsunami of insolvencies yet across Australia either. In short, since the SBRP came into effect, it's only been used 18 times, with some possible overlaps with other forms of external administration if any restructuring failed. You'll see NA for all years except 2021. It's clear there hasn't been a great demand for SBR. Object of Part 5.3b is shown. We know that the Corporations Act created a uniform legislation administered by ASIC. This part aims only to provide for a restructuring process. Part's objective doesn't aim for recovery or survival like voluntary administration covered by Part 5.3a does. It's merely an attempt. This new insolvency regime or scheme was created to address the anticipated effects of the phasing out of government assistance. Now we will discuss the benefits and drawbacks of the new procedure. I guess the question at the crux of it all is it actually simpler for MSME? Unlike voluntary administration, SBRP is faster, less regulated, is not a one-size-fits-all approach, and directors retain some control over the business. So shouldn't this equate to lower costs? Or perhaps, is it still not low enough? To discuss the simpler process element of the question, you have to first understand how complex previous procedures under voluntary administration were. In fact, voluntary administration administration is very similar to SBRP. Overall, we see negligible simplification in the law, despite plenty of differences listed in a 2-column table in the explanatory memorandum. But only time will tell whether the different processes in SBRP will change through amendment of the regulation. SBRP introduces debtor in possession, means that company directors retain control of daily business affairs for the company as a whole, without subordinating themselves to the restructuring practitioner. Directors must also develop a restructuring plan for creditors' approval. Contrastingly, for voluntary administration, only the administrator can control the company and create a deed of company arrangement for creditors. Deadlines are shorter for SBRP in that the restructuring plan has to be submitted within 20 days, with a 10-day extension possible, instead of 35 business days for the voluntary administration. Only a majority of creditors votes in terms of their value, not their number, is required for the plan to become binding, unlike voluntary administration. Still, SBRP seems to benefit directors slightly more than creditors. Our arrangements evolved from the UK, which gave greater rights to creditors. Now it seems a US approach of giving greater powers to debtors has been introduced. To discuss the degree of survival, we have to first understand the efficacy of previous methods for MSMEs. As you can imagine, most insolvent companies do not survive, and those that could potentially recover under a modified scheme are barred from the SBRP anyway. We have interpreted simplify to mean everything from lower costs and formalities to accessibility and clarity, while survival is the primary goal which must be achievable for SBRP to have any meaning. I'll now turn to the arguments to be made for and against whether current SBRP achieves the two elements. Some of the SBRP's problems are listed, including that it is still complex and that it may not intervene until it is too late, and so on. Note that ongoing difficulty in balancing between interests of impartiality against lower fees, because it consumes most of the funds of the creditors, despite the remuneration determinations and creditors' ability to remove practitioners, might suggest that a government liquidator is necessary. In any case, for example, the company is or is likely to become insolvent is a lot more limited than financial difficulties in the UK, which would be a broader term to allow businesses at any degree of risk to use this new scheme. Present slimming down of VA, create SBRP, likely hasn't fully reduced practitioner involvement by a substantial amount. Perhaps greater consultation was necessary if SBRP was to be of more practical use. SBRP's limitations include that it's too narrow in terms of its criteria, and almost all critics touch on how the eligibility criteria limits the uptake, and the liabilities test is too strict, and obviously some other limitations are less of a limitation as much as they are safeguards against wrongdoing, but to me it does appear somewhat limited. Benefits include, well, in theory, it should suit the majority of small businesses, and previous case law can be easily applied here. In terms of division of labor, all three members independently researched and discussed the various pros and cons of SBRP, and at times comparing, at times exploring issues that might not have been found yet, and statutory interpretation as well. Now, regarding the articles, we have several sources which include the Janus Feist, which suggests that the law itself is mismatched with the legislator's promises. For example, the text explains that the eligibility threshold effectively excludes desperate businesses from the SBRP, and that the practitioner still has too much power and control, and that the regulations are overused. We'll use this source to cement our view that right from the get-go, there were doubts cast on the effectiveness of SBRP. In terms of the UN CITRO's principles for dealing with MSMEs, they recognize the need for special laws just for MSMEs. And in terms of the chimera of restructuring reform, it contains a strongly supported argument that some key requirements of debtors, creditors, and practitioners haven't been met. Also worth mentioning that there are 3 insolvency experts in the law school: Professors Chris Symes, David Brown, and Beth Nosworthy. And through my research, I began to find this topic to be very fascinating. Our argument could also be that the SBRP does provide a variety of benefits compared to the existing insolvency resolution mechanism. To effectively prevent a larger number of small to medium enterprise MSMEs from business collapse, there are a number of limitations in the SBRP to be overcome. Achieving the SBRP's objective requires utilizing broader approaches. The Corporations Act must support the implementation of restructuring mechanisms in a further simplified way, but also directly ensure MSME survival in a more involved way. These future developments will empower the Corporations Act to achieve the best possible outcomes for MSMEs. So in our paper, we will analyze both for and against the effectiveness of the current Corporations Act, or the specific part 5.3b, to reach a preference and support an argument for perhaps reform. And we'll cover each sub-issue in perhaps one paragraph, which will start off with the actual issue and then our point that we want to make and some sources to back up, suggest support, and then to conclude. And this conclusion would then provide the basis and context for the next sub-issue in the next paragraph. So we'd try to present our interpretations of the part 5.3b, would show examples, if possible, of its application, and present arguments to support the reform and perhaps not to support the reform, and maybe even predict how this reform might help deliver outcomes. Conclusion would be that the Corporations Act reveals that the aim of this SBRP was not ambitious enough, and the expected failure to achieve its objectives is evident from the lack of simplicity and the difficulty of this mechanism in ensuring MSME survival. The important findings on the issues and limits relating to the process have many possible implications. However, what is definite is that successful restructuring of MSMEs requires broader and more proactive legislation.